20th, 2018 is now in session. My name is John Michael. I'm the zoning administrator for the Metropolitan Government, and I'll be presenting the cases to the board for their review today. Here at the outset of the meeting, we would respectfully ask everyone to silence your phones, tablets, or any other electronic devices. Each of the folks who will present to the board today have a limited amount of time, so we don't want any disruptions that would cut into their time for presentations. And of course, we thank you for your help with that. In each of today's public hearings, the board will be presented with correspondence that's been submitted both in support of and opposition to each of these cases. The board reviews correspondence and recommendations from other government agencies as well in preparation for the hearings. In today's hearings, the staff will make the presentation of the photographs, site plans, maps, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will have the opportunity to present his or her case to the board. After the appellant's presentation, the board would hear from any of those wishing to speak in support of the appeal that's been presented. Then, if the appeal has opposition, the board would hear from those parties at that time. At the conclusion of the opponent's presentation, the appellant will have an opportunity to come back and make rebuttal presentations if they wish. Under BZA rules, the appellant has 5 minutes to make a presentation to the board in support of their case. In contestant cases, the BZA rules allow 10 minutes for each side to present that testimony. Of note, that's 10 minutes per side, not per person who wishes to speak. Should the appellant wish to provide rebuttal testimony, he or she should reserve some portion of that originally allocated 10 minutes to use as rebuttal. At the conclusion of each hearing, the board will deliberate and then vote on the case in question. The board is vested with the power to do so under the provisions of the Metro Zoning Code, specifically Section 17.40.180. All of the section numbers to which we refer today come from the Metro Zoning Code, which applies to the entire jurisdiction of the Metropolitan Government. The Zoning Code was adopted by the Metro Council and became effective on January the 1st, 1998. I will introduce the entire Zoning Code and make it part of today's record for each of the cases. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville network and later uploaded to YouTube, it's imperative that anyone wishing to address the board come forward to do so, sit at one of the microphones here at the front of the room, and introduce yourself by name and address before making your presentation to the board. Anyone speaking from the gallery will not be recognized, and no comments made anywhere other than at these microphones will be part of the record. The Metro Code requires 4 of our 7 board members in order to establish quorum. Therefore, none of the cases will be heard or no votes will be taken until we achieve that quorum of 4. In the event that our board loses quorum during the course of the meetings, by law, the meeting must end immediately, closing out, and any cases not heard from today's docket would be added to our next agenda for the board meeting set to take place on October the 4th, 2018. In the event that 5 or more members are present, and an appeal fails to receive 4 affirmative votes, which is required in order to grant an appeal, then a case would remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to our board rules of procedure, an aggrieved party may appeal board decisions. A party may appeal to the Chancery Court within 60 days of the original hearing date. And additionally, an aggrieved party may file a motion for a rehearing within 60 days of the original hearing date, pursuant to the very specific terms under the BZA rules of procedure. After that time elapses, the board's action is final and no further action can be taken. For the appellants, if your appeal is granted, you are in fact required to come obtain the permit for which you have applied. A board's approval only stays good for 2 years. After that time, you go back to start with the new application, new notices, new signs in the yard, and a new trip to the BZA. It should be also noted that if any false or misleading testimony is presented to the board, then board approval could be revoked at a later date by means of a show cause hearing before the BZA. And with that, Mr. Chairman, I would submit that all cases have been filed in the proper order, all the appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. A couple of preliminary announcements before we require any board action. First, case 316, again that's 2018-316, involving the property at 439 West Bend Drive, has been withdrawn by the appellant. Again, case 316 withdrawn. Next, from page 2 of your docket, case 2018-480 involving the property at 1301 Porter Road has been deferred to our October 18th hearing date. Again, case 480 deferred to October the 18th. Next, case 2018-501 involving the property at 1414 Dickerson Pike has been deferred one meeting to the October 4th agenda. And finally, a later addition to this list of deferred cases at the beginning of the end of page 9, case 2018-272 has been deferred one meeting to the October 4th docket as counsel for the appellant has fallen sick and unable to attend today. Those items, case 316, case 480, case 501, and case 272 will not be heard today. For information for purposes here in our audience, the board utilizes a consent agenda. One board member reviews the record for each case prior to the hearings and identifies cases where appellants met the criteria for their requested action. If the reviewing board member determines that testimony in that case would not alter the material facts, then the case is recommended to the board for its approval on this consent agenda. We will now enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases identified for consent agenda, please indicate so by raising your hand. Make sure we see you. That case would then be removed from consent agenda and just heard in its regular order. Mr. Chairman, as you know, we have a considerable list of items on the consent agenda, so we'll go through them slowly. The first such case is 2018-487 involving the property at 2508 Finland Street. Is there anyone here in opposition to case number 487? Seeing none. The second case identified for consent agenda is 2018-491 involving the property at 1989 Gatlin Drive. Is there anyone here in opposition to case 491? Seeing none, the next case identified for consent agenda is 2018-492 involving the property at 2505 Eastland Avenue. Is there anyone here in opposition to case 492? Seeing none, the next case recommended for the consent agenda is 2018-502 involving the property at 111 23rd Avenue North. Is there anyone here in opposition to case number 502? Seeing none, the next case recommended for consent agenda is actually it's a late name deferral, Mr. Chairman. Case 2018-503 involving the property at 2414 Lebanon Pike, although originally recommended for consent, actually has to be deferred administratively for one meeting as we are required to receive a formal recommendation from planning because this property is in a UDO. So we'll hear that on October the 4th. Again, that's case 503 to be heard on October the 4th. The next case recommended for the consent agenda is 2018-505 involving the property at 1995 Gatlin Drive. Is there anyone here in opposition to case number 505? Seeing none, the next case recommended for consent is 2018-506 involving the property at 521 Arrowwood Drive. Is there anyone here in opposition to case 506?
Yes, I am.
That case will be heard in its regular order. The next case recommended for consent agenda is 2018-507 involving the property at 614 Garfield Street. Is there anyone here in opposition to case number 507? Is the appellant present for case number 507? Is any representative for the appellant present for 507? Mr. Chairman, let's hold that one for a moment and we can pick it back up on consent later in the meeting if that's okay, just to be safe. The next case on the proposed consent agenda is 2018-508 involving the property at 849 Cherokee Avenue. Is there anyone here in opposition to case number 508? Seeing none, the next one recommended is 2018-509 involving the property at 6201 Hickory Valley Road. Is there anyone here in opposition to case 509? Seeing none, the next case on the consent agenda is 2018-510 involving the property at 5115 Harding Pike. Is there anyone here in opposition to case 510? Seeing none, the next case recommended for consent is case 2018-511 involving the property at 908 Halcyon Avenue. Is there anyone here in opposition to case 511? Seeing none, the next case on the proposed consent agenda is 2018-512 involving the property at 2105 Eastland Avenue. Is there anyone here in opposition to case number 512? Seeing none, Mr. Chairman, I want to make sure I've struck the correct items from our proposed consent agenda before proceeding. With all four members of our board present at the moment, I can report that the consent agenda remains as follows. Case 487, Case 491, Case 492, Case 502, Case 503, Case 505, Case 508, Case 509, Case 510, Case 511, and Case 512. Did I leave anybody else? Did I announce that? Sorry, I announced 503 as part of your consent agenda. That's the one that was deferred from Lebanon Pike. So that's 487, 491, 492, 502, 505, 508, 509, 510, 511, and 512 on consent agenda. We would solicit a motion from the board on that consent agenda.
Okay, those following cases that John Michael read have been properly moved to the consent agenda. Is there a second? Second. Motion's been made and properly seconded. Any discussion about the consent agenda? Seeing none, all those in favor of the consent agenda signify by saying aye. Aye. Opposed? Consent agenda passes 4-0.
Ladies and gentlemen, if the case that you're here for was just announced on consent agenda, you're all done. You can see the code staff as early as Monday to pursue the permit for which you have applied. Wish you good luck with your project. All other cases not called on consent agenda, not called on deferral or withdrawal agendas, will be heard in their regular order today. Mr. Chairman, we'd like to use this opportunity to recognize elected officials who've joined us at our BZA meetings. I know we're joined by at least one district council member who I saw earlier. Councilmember Brett Withers from Council District Number 6 is here. And in a moment, I suppose we can recognize him. He may have stepped out for a moment. Is he? More fortuitously, we are joined by the district council member from Council District Number 20, Mary Carolyn Roberts. Council member, do you wish to address the board? No. Very well. Recognize you at your leisure when any case of interest comes up, council member. And Mr. Chairman, if Mr. Withers emerges, we'll bring him to the podium.
Is it possible to hear 499 first?
I'll take that.
It's not.
John Michael, I think Councilman Withers, two cases that he came for were both on consent, so had nothing else to add.
With that breathtaking degree of judicial efficiency here in our meeting, we'll proceed and take the first case scheduled to be heard. I believe the council member from District 20 is speaking with the appellant for case 499. There may be a request to take that out of order for the benefit of that hearing, and we'll consider that. Perhaps go ahead and get started with the first hearing and then going from there.
Okay, very good.
Mr. Chairman, the first case that we'll present is 2018-454. As you may recall from two or three meetings ago, this is a property, 921 13th Avenue South. The request is for variances from garage orientation requirements and driveway size requirements in the R6A zoning district. As you'll recall, the alternative zoning districts require certain design guidelines, including no front-facing garages, restrictions on the number of driveways, regardless of the number of residential units in the HPR setups. The aerial for the neighborhood shown here will remind you, of course, that is an unusual, pie piece-shaped lot. They created certain restrictions leading to this variance request. Landmark Homes of Tennessee is the appellant. Is the appellant represented today or have anybody here? Mr. Chairman, I believe that was the case last time we sat and called this case.
I'll move that we deny the variance, and if they want to reapply, they can. This is the second time it's been on the agenda without them showing.
Okay, motion's been made. Is there a second to that motion?
I'll second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye, opposed, passes. So, John Michael, their request is denied for lack of, well, they weren't here, so they're welcome to reapply.
Mr. Chairman, the next case on our docket is 2018-486. That involves the property at 5636 Kendall Drive in Council District Number 20. The owner of the property, Anne Marie Danko, has requested a variance from the accessory building floor area restrictions in an RS 7.5 zoning district in order to construct a screened-in porch to detached garage. The property shown here at that corner along Kendall, and the site plan shown here gives some indication of the layout. From my recent site visit, from kind of catty corner into the property, then these three slides show down Kendall in the upper left-hand corner, from the cross street looking back toward Kendall in the lower left, and then across the cross street in the lower right. Is the appellant present for case 486? Very well. Is there anyone here in opposition to case 486? Seeing none, the appellant will have 5 minutes to make the desired presentation. Just introduce yourself by name and address.
Oh, please press the button at the bottom, the red light. Yes.
Great. Okay. I'm Anne Marie Danko at 5636 Kendall Drive, and my appeal is to construct a covered screen deck in the backyard. So I tore one down that's about the same size, and I want to build another one to replace it just on the back side of the garage instead of up against the house. Currently, it's a concrete patio.
Is it covered?
The patio?
The patio's not covered.
Not right now. No, it's concrete.
So the
But
one that you tore down, it's the exact same?
It's very close to the same size.
And
I
it
have
was attached to your home, but
photos.
and you just want it attached to the garage instead of your home.
Correct.
So you're not adding any additional covered space on your property, you just want it attached to the garage.
Correct.
We also have a letter from your duly elected councilperson, Mary Carolyn Roberts, who says she's in support of this. So
Yep, she's here.
Very good.
And the neighborhood association and all the surrounding neighbors, I think, have said
Yes.
that they agree.
So you did your homework, you
Thank
reached
you.
out to your elected official, you reached out to your neighborhood associations. There doesn't appear to be anyone here in opposition. So any other questions for the applicant? Okay, thank you. We're going to close the public hearing. Discussion.
Yeah, I don't have an issue with it, especially since she is moving one covered porch from one to the other. I think it does deviate from the garage, but I think, again, she's done her homework, so.
Yeah, and I'm happy that the councilperson and the neighborhood association both are in support of this. So is
Yeah,
that a
so
motion?
I'll move that we grant the variance to allow the accessory building floor area restrictions to be exceeded by the 190 square feet that the applicant has asked for to build a screen porch addition to the detached garage with the condition that that screen porch not be enclosed at any time.
Okay. Motion's been made. Is there a second?
I'll be glad to second it.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Mr. Chairman, the next case is 2018-488. That involves the property located at 1020 Davidson Road in Council District Number 23.
John,
Yes.
Michael, are we ready for the 499 case?
Perhaps. Preston, let me put you on hold for a moment. Councilmember Roberts wished to see case 499 brought forward to the board. If the board wishes to take case 499
Yes.
at this time, we can certainly do so.
We do.
All right, with that, case 2018-499 comes to us from Roger Potter, the appellant for the property at 5804 Morrow Road. We'll invite the appellant forward. The request is for a variance from sidewalk requirements in the R6 zoning district. The property shown here in a pre-demolished state gives you some indication of the unusual angled corner there as you cut through the upper portion of the Nations. The site plan submitted shows a proposed layout for the construction that will take place there, but of course the request being strictly about the sidewalk requirements, the site visit photographs hopefully tell a cleaner story. From the near intersection there in the lower right-hand corner and the view across Morrow in the upper left, the view up and down the applicable streets, as you can see, to the extent that's a sidewalk at all going northbound, it ain't much of one. That's my technical legal analysis, Mr. Chairman. The council member is present and has chimed in on this, of course, giving us some feedback with regard to what she's looking for in the district. The appellant has modified his original request somewhat, and he can address that. With that, please introduce yourself by name and address, make the desired presentation, and Mr. Chairman, of course, we hear from council members whenever they wish to address issues.
Yes.
So my name is Mary Carolyn Roberts. I'm the council person for District 20, and I want to say thank you for all you all do. I know you're in overwhelming. It's got to be hard, and I appreciate your service. So Mr. Potter has been so easy to work with on this. I think we've kind of worked out a solution that maybe suits everyone in the neighborhood and works for him as well. His wanting to pay into the in lieu fee was not something that I was in favor of, because we share a district that is not necessarily a council district, and I'm always afraid I'm not going to see that money in my district. And the sidewalk, I feel like, needs to be on Morrow. So he understood and talked, and his reluctance was he does not want to be in a position where he has to pave 58th Avenue, because that's not fair to him. So what I think the solution is for both of us is if they put a sidewalk on 58th Avenue and they put a sidewalk on Morrow, I think we're all on board together. And if that is something that
I'm sorry, you said if you do what on 58th Avenue?
he's going to put a sidewalk on 58th and a sidewalk on Morrow.
To the new metro standards with the
Yes.
curb and gutter and all that?
Correct.
Okay.
Now, the one on Morrow, is it just going to extend the current sidewalk because it's only got a 3-foot grass strip, so you're going to pull it back to do the whole 4-foot?
Exactly.
So I guess the question is, why are you here?
Well, we just worked it out. We just,
They couldn't.
yeah.
Yeah.
Well,
What do you need us to do if you worked it out?
I know, I had spoke trying to go through the process of the permitting, and when I got to Public Works, I was, I ran into a roadblock. Said the area along 58th Avenue is a narrow road, and they didn't really want that used as a road. Public Works didn't, as a full-size road. They'd rather leave it as it is. So our question was, where does the sidewalk go, with the right-of-way there? And so anyway, I believe we got an answer on where we will go with the sidewalk now. And we'll put in to meet the requirements, with the size, the grass strip, sidewalk size, all the.
I mean that you're withdrawing your request from us because it doesn't sound like we need to do anything.
John Michael, do we need a vote
I mean,
on
if you
this?
follow codes, we don't need to do anything.
I think you actually,
I don't think, I can't, sorry, I was so late to the arrangement that I'm not positive it was exactly what's allowed under the code. As a result, there's no harm in having the board approve the proposal put
Let's approve
forth.
what they have come to. We really appreciate you being here and talking to your council member. As I like to point out to all the sidewalk people that come here for variances, we didn't pass the sidewalk ordinance. The Metro Council passed it unanimously with many co-sponsors, I believe over 30. And so those asking for a sidewalk variance, if you have not talked to your council person or you don't have a unusual topography or some other issue, you're probably going to have to pay into the fund. So those sitting out in the audience that haven't talked to their council person, you might want to defer. You might want to, see if you could come up with a more agreeable solution that is what's happened before us. So you have a motion.
It is a 5-foot sidewalk? Okay, yeah, so I'll move that we close the public hearing?
Yes, we're close to public hearing.
I'll move that we approve the variance, provided that the applicant provide a curb and gutter, 4-foot grass strip, 5-foot sidewalk along Morrow and 58th, as stated during the hearing, and if there are other aspects of the law that are required, that those will receive a variance in terms of the sidewalk law.
Okay, motion's
Is that
been
fair
made. Is there a second? I'll second it. Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. Good luck, and thanks for your negotiation. John Michael.
Mr. Chairman, we'll circle back to case 2018-488. This involves a property at 1020 Davidson Road in Council District Number 23. Preston Quirk is the appellant on behalf of Mr. Cousins, the owner of the property at this location, shown here on the zoning map, an RS40 zone property. From the aerial, see the grassy corner there, kind of one of the outer edges of Davidson Road. The site plan submitted shows the proposed construction for an addition to the single-family residence. The request is for a variance from front setback requirements. As you know, with contextual street setback requirements, we can sometimes see some pretty lofty numbers. Here, the requirement, I believe, was in the ballpark of 95 feet from the contextual requirement. The request is for something more along the lines of 55, 56 feet, the variance thus being somewhere around 40 feet reduction from the contextual requirement. From my recent site visit, views of the front of the property from the intersection, view down the side street in the upper left-hand corner, and back down Davidson in the lower right. Is anyone here in opposition to case 488? Seeing none, the appellant will have 5 minutes to make the desired presentation. Just please introduce yourselves by name and address.
Okay, I'm Preston Quirk, architect with Quirk Designs, here representing my client, John Cousins, on my right. This is existing house in Westmead. It's a ranch, probably built, I think, in the 60s sometime. John has lived there about 15 years, done some interior renovations to it, added a nice deck probably 10 years ago. We're here today. He would like to add a open or covered porch to the front of the house, protruding 9 feet from the front of the current house. The front of the house now is just I don't remember if John showed a picture there. It's just a very flat Westmead ranch house. We're just proposing an open porch here. He wants to stay in this house, not tear it down and rebuild like a lot of people are doing these days. And I had a case similar to this back in the spring. We were at House on Garden, and that was approved. In this case, you have a lot also where his house is, if you look at the site plan, it almost looks like the lot was intended for the house to maybe face the side street, which is Wesley Wood Drive. But when it was built, it was built facing Davidson Road. So when you do the average front setback on it, the front setback line is actually behind the house in this case. So, just the position of the house on the lot is a lot of the reason that we're here. So I guess we're respectfully requesting approval. I would say that, this shallow lot configuration is the hardship in conjunction with just the location of the house on the lot and how it's situated now. So,
Okay, questions, board members? Do you have anything else to add?
I was just going to say, I have a sketch of the proposed porch, if that matters.
Yes. Our architects love to see those kind of things. Okay, let's close the public hearing and discussion.
I think absent opposition, they've made a reasonable request for a variance based upon the shape of the lot. But I'll defer to the architects when they see the drawing.
It looks nice.
Thank you.
But we're not here to debate the aesthetics of it.
Understand.
To me, it's a standard. It's the type of case we've heard before. Without opposition, it's reasonable. I think as long as the applicant's agreeable to a condition that it not be enclosed, that it is a porch, and down the road, you won't be enclosed. I'm happy to make a motion to approve the front setback variance for a 9-foot by 31.5-foot front porch, provided that the front porch not be enclosed without additional permission from this board.
Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. Good luck.
Thank you.
John Michael.
Mr. Chairman, the next case to be presented is 2018-493 involving the property at 1700 8th Avenue South in Council District Number 17. The request is an Item D appeal. Item D, of course, is a request for a change in legally non-conforming use or structure, in this case use. As the retail use at this property for many years, you'll notice, by the way, the split zone lot that we show you here. The pink highlighted area indicates the lot in question. The dark line toward the rear of the lot is a separation between CS zoning, commercial services, up on 8th Avenue, and that's actually R6, or residential minimum 6,000-foot lot size, on the rear. Last summer, zoning staff, namely the prior zoning administrator and I, reviewed photographs, aerial photographs from the 1960s to confirm that even as far back as that, the rear portion was used as parking as an accessory use for the retail uses up along 8th Avenue. Therefore, that was considered a legally nonconforming use. However, this case comes to you today because the, by right, use planned for the CS portion of the lot, which is automobile rental, will utilize that same parking area, but in this case, we believe it's a change from vehicle parking as an accessory use to the retail use to vehicle storage, given the nature of the business with a car rental company. So the question before you will be, is that a permissible change in use under our Item A standard? 1740.650 of the zoning code is the applicable section, and that talks about whether or not this is more compatible or less compatible with the base zoning for those areas. That said, the appellant is Adam Seeger on behalf of the property owners. Mr. Seeger is present today. Is there anyone here in opposition to case number 493?
Please come forward.
Seeing none, Mr. Seeger will have 5 minutes to make the desired presentation to the board. Please just introduce yourself by name and address.
Thank you. My name is Adam Sager. I'm with Dale and Associates. We are the civil engineer for the company that has bought this property, and they are taking the existing building in the CS zoning and making it into an automotive rental, enterprise rental car. And the back of the property, I don't know if you have the aerials up, I think they're in your packet, but you can see this back parking lot has been used for a long time. I believe a record shop, coffee shop, various retail uses have been in these buildings for a long time and have continued to use that back parking lot. The back parking lot is kind of paved, kind of gravelly. It's just one of those old parking lots off of an alley. Our client is coming in, and we're going to clean up the entire site. The buildings are getting redone. Like I said, on the CS portion, we are by right on our use. In the back portion, we're going to continue to park cars. But like Mr. Michael said, for this use, I guess the semantics would say instead of considered parking, it would be storage. But we're going to continue to use the parking lot as it's always been used. In addition to that, we're putting stormwater treatment and a landscape buffer along the back to help mitigate anything. We are shrinking up the paved areas. So after we are done with the site, there will be less area to park on in the back than what there is today. We are cleaning up some alley dedication areas for public works along the edges. This is an odd-shaped property that kind of became an alley, and it's been offset, and just a lot of developments have been happening back behind here for a number of years. And so we're going to clean up all those property lines, and can't think of anything else, but that's the gist of it. And if you all have any other questions, I'd be happy to answer those.
The main part of the business is going to be in the front part of the structure, this house? That's not going to get torn down, is it?
That is correct. The building, let me rephrase that. Part of the buildings are getting torn down, but the use is operating out of the existing building.
Which part of the building is being torn down?
As you're looking at it,
the Grimey's Records building, right?
The original Grimey's is to the north off of us, and Grimey's 2 is the one that's on the property.
Okay.
And that has already been torn down.
The white one, the white building.
The white building we're keeping.
Okay.
And so if you...
That got torn down.
That is staying.
Oh, that's
so on the
staying.
right side where you see the frothy monkey symbol, that got taken down.
Okay.
Yeah.
So-
And I don't know, do y'all have this plan right here? It kind of shows what building remains and how the driveway is being utilized off of 8th Avenue.
So where do cars get washed?
Inside the building. This is a kind of a 2-story building. From the front, it looks like 1 story, and as you go around the right side, it dives down. Elevation goes down pretty steep. And so if you're looking at the screen where it says CS and CS zoning, that's actually a story below 8th Avenue. And so they will pull in underneath into existing bays, and they will get serviced or washed in that area.
Yeah, I mean, I guess so. I mean, the council member Sledge just sent a letter saying he doesn't support it, and because it's not compatible with R6 zoning, but that was the extent of what he had to say, so there's not a lot more detail. But I guess if you're looking at, is that lot more or less non-conforming, how is a cleaned up paved formal parking lot less nonconforming than a gravel lot people park cars on?
Less non-conforming?
I mean, yeah, well, the same or less. I mean, you're saying it's either the same, it has to be the same or less. By rule, if we determine it's more, then that's a problem. And so I think, is that right?
So the legal standard for an item D appeal in a non-residential district, which is a little bit weird, as we said, because this is split zoning.
Yeah.
But it would have to be determined by the board to be more compatible with the surrounding land uses. So more compatible is another way to say what you were saying, which is less non-conforming.
Okay,
Yeah.
more compatible. I would say, one, this property is all one parcel, and so it is unusual to have a split zone property. In all likelihood, this property should be CS all the way throughout, and we will maybe even consider rezoning that back portion to cleaning it all up in the future. However, because we have that back portion that still remains in an R6, being more compatible with surroundings, we will be increasing pervious area, meaning grassed areas. So we're taking some gravel pavement areas today, turning it into grass. We're installing a 10-foot B3 landscaping buffer in the back stretch, so we're adding landscaping strips. We're installing a rain garden, which is additional pervious area that'll have plantings, vegetation. So it's going to be less pavement than what exists there today. And we're continuing the exact same use that it's always been.
So is the 10-foot grass, is the 10-foot landscape buffer, is that the buffer that's required from going from CS to R6, or is that?
Correct.
Okay, so you're putting a commercial landscape buffer in the R6 zone space?
Correct.
Okay.
Any other questions of the applicant?
The letter from the councilman indicates that there wasn't any discussion with neighbors or with the council person about this particular use. I just wondered if you did that on purpose, or did you know that was a possibility to have that discussion?
When we originally started off on this project, we received confirmation from the codes department that this was illegally.
Wait a minute. She asked about the council person.
I am. I'm answering that.
Yes.
And
I don't want to hear that you talked to codes. Did you talk to the council person?
no, we haven't talked to council.
And why not? And that's the kind of glaring thing. This is a big use.
And I understand, that's what I'm trying to explain, is that when we first got on this project, we were provided a letter that said this is a non-conforming allowable use, and we proceeded with the site plan all the way up until we've gotten permits. They've gotten building permits. They have already started on the site. And very recently, we have learned that this was being considered a storage instead of parking. And so we immediately filed with the department and did not think that we needed to go back to the councilman because this was more of a technicality in our eyes, and we've already kind of farther down the road.
Technicality, you're asking for a variance in front of us.
Correct.
Right? And so you should be talking to your council person who is very active in the 17th District, Councilman Sledge.
Okay.
This isn't your first time in front of us. You know how we work.
Correct.
And he has written us saying that he's not for this.
But I think he's not for the use, and the use is allowed in the zoning
Oh, I
code.
get that. So this is a 7-day-a-week business?
The rental car place?
Yes.
I'm not certain, but probably. I mean, we've all kind of know how enterprise works. It's at least 6 days.
I want to ask a question.
Yes, ma'am.
I have enterprise rental place close to me, and it's wonderful to have it, so I don't have to go to the airport. That would be the next nearest place to get a car. What about, have you talked to any of the adjoining neighbors, even though you didn't have an official neighborhood meeting? Did you have any conversations with anybody in that area about having this as a car rental? Because I agree, as I read Councilmember Sledge's comment, he doesn't think that it's the best use for that property, but we have to look what is the legal use for that property. Have you spoken with anyone about this?
No, but like I said before, we have a legal use on the CS property, and so coming before you today is something that we have learned very recently. So up until this time, I have not. I don't know if my client has talked to the neighbors. So.
What's the plan if the variance is not approved? Will you just continue to use that back lot as parking?
I would assume so.
Any other questions of the applicant? Anything else to add?
Yeah, I mean, the only other question I have is what type of lighting is planned for back there? And, that seems to me the 10-foot buffer is appreciated. It looks like the drainage system is going to be at the end of the property, which is also a buffer. And the only thing that I think might be a real irritant as a homeowner would be if you had, tall 24/7 lights in the back.
There is existing lighting out on poles on the property today, and we are maintaining those. We're not adding any new lighting towards the R6 portion of the zoning.
Okay. That's all. Thank you.
Is there lighting towards some other part of the property?
In the front along 8th Avenue, whenever we're putting in a new building, they'll have wall packs on the front of the building and a lighted sign. So that's a change. But when you get about halfway back there into the parking lot, there's existing poles with lighting already on them.
Yep.
And those are going to remain.
Okay. Any other questions of the applicant?
Well,
Okay.
let me just ask the process so the vehicles are going to be stored there. Someone is going to come into the business, want to rent a vehicle. The employee is going to go to the back lot, pick the vehicle up and drive it to the front? Is
Correct.
that about what's going to happen?
Yes, that is correct.
Okay. Any other questions? We're going to close the public hearing discussion, and I want to start by asking our lawyer to read to us the standards again about this item D appeal and what are we supposed to look at.
17, Metro Code 174650 C4 is what applies to this application, and it says in all mixed use and non-residential districts, an existing non-conforming use may be changed to a new non-conforming use upon a determination by the Board of Zoning Appeals that the new non-conforming use will be more compatible with surrounding land uses than the existing non-conforming use. So your job as the board is to look at how it is currently, it is legally non-conforming now. What is that legally non-conforming use, and how does that compare to this proposed new non-conforming use? And if the proposed new one is more compatible, then you can approve it.
I have one more question.
And so do I. Yep. Let's open up public hearing.
Is the R6, is there going to be an opaque fence at all in the back? Or is it just a 10-foot landscape buffer? I mean, like a wooden fence, when you can't?
The entire back lot that we're considering will have a fence along it, like a chain link, I believe, along the alleyway. I think along the back property line, we're putting in an opaque fence, yes.
But not along the alley side for the
B3.
3 houses that are on the R6 side?
Correct. On the alley side, the alley's encroaching into the property, and we're dedicating that back over to Metro.
I'm not talking about that. I'm not talking about the hatched alley, or you talking about
the north portion of the alley.
Okay,
correct.
I'm talking about the south alley. It says alley, and then you're coming and going halfway down the alley, but then you have houses that are like where it says 1700 8th Avenue South, just to the left of that typeface. You've got kind of 3 lots there. Will that have? I mean, that's the only thing. To me, an opaque fence, kind of all around that R6 area, would keep a neighbor from looking at a car. I mean, I know you're going to put the grass, I mean, the buffer, but, and again, I'm just asking if you would be willing to do that. If I don't know that you have to. But.
Certainly. We're proposing it along the back portion of the property already.
Okay.
And so to wrap that corner, I would just want to make sure and double check with the client and Public Works and make sure we aren't blocking off anything permanently from their alleyway.
How many cars will be back there?
gosh, I don't have it drawn. I don't remember off the top of my head, Mr. Ewing, I believe it was around 30, maybe, 30 or 40.
And that lot is not going to be paved
It is going to be paved.
It's gonna
It'll
be
be
paved.
repaved.
and striped and everything?
Correct.
Any other questions? Okay, close public hearing discussion.
I would say that a lot that is part gravel and part concrete is somewhat dangerous, and that the paving of the lot would be an improvement. So I guess I would lean toward allowing him to do this.
Yeah, I mean, the 10-foot buffer, landscape buffer, treating, I mean, it is R6 zone, but they're treating as if it's commercially zoned, so they're addressing their neighbor as if it was a commercially zoned piece of property. I asked about the fence, and I know they're putting it on one side. If I were the alley person, you might like to have that too, but I also know a 10-foot buffer, depending upon what's planted, could do that, and it's across an alley from me, so
But it's also headlights.
Well, there are, but you're probably going to be going front and back to 8, but you're right, there are headlights, so, that's not to say it, I don't know the properties, they may have their own fence that's there already, so they shouldn't necessarily have to be required for that, so I'm unless someone else feels really strongly about it, I'm fine with the plan.
Does anyone have a motion?
Well, I'll make a motion that the new requested use is more compatible with the surrounding area for the reasons that the paving will improve the look. They're making other improvements to the property as a whole. They're going to add the grass buffer. I do think we should require, to the extent that we can, a fence, even though we don't have neighbors here requesting that. I think that's something that would be helpful in that area. So I would make a motion.
So the
solid fence.
requirement would be a solid, an opaque fence
An opaque fence.
that meets
Code
the requirements of Public Works.
Yes. That's
And
what I
no
thought.
chain link fences?
In the R6 piece.
Yes. Are you fine with that?
I'm fine with that because I think they're going to want some fence for security anyway. I think an opaque
Yes,
fence.
applicant had it.
Yes.
With regards to chain link fence internally, R6 zoning, if you just word it as though no chain link in the R6, that would be a detriment because internally how the site operates, there is going to be a chain link fence inside of the property with gates and things to close all of that off. So I'd ask you to just
They don't make
reconsider
gates
that.
for opaque fences?
No, inside, like right here, in here, like for their own protection.
Oh, between the two properties?
So if we set an opaque fence on the property line, that'd be okay.
I believe that we could accommodate it on, as you're looking at the plan, on the east property line where we're already putting one, and then even on the south property line, because that's an alley that really isn't being used. However, on the north property line, that's an existing alley used by existing residences that I don't know if we can put an opaque fence in there because it's in the pavement with power poles and all kinds of things.
Within the east and the south.
The east and the south is where we probably could
agreeable.
accommodate.
Okay. So,
I would make that my motion.
okay, motion's been made. Is there a second?
Yes.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck.
Thank you all.
John Michael.
Mr. Chairman, the next case is 2018-495 involving the property at 518 Elgin Street in Council District Number 16, shown here on the aerial. Caprice Palmer is the appellant and co-owner of the property at that location. The request is for a variance from setback requirements in this residentially zoned district in conjunction with proposed construction of a single-family residence. The site plan shown here shows the proposed layout of the lot. From our recent site visit, staff made it out on this one. The view up and down the street. With that, is the appellant present? Yes, great. Anyone here in opposition to case number 495? Seeing none, the appellant will have 5 minutes to make the desired presentation. Just introduce yourself by name and address and explain the basis for your request for a variance from setback requirements.
Hi, my name's Caprice Palmer, 518 Elgin Street, and our request for the variance is that you can see on how the lot that we have goes far left to right, where the other ones on the street, on that side of the street, go deep instead of long. So when we submitted this, my understanding, and this is the first time for us, so we weren't quite sure. We thought we were doing it all correct. But they were saying that it has to be an average. Now, the houses that are across the street, and I know you can't see that on that, they are more into line of the lots that in the depth of what we have. So we're just asking to set it next to the house that's next to it, basically in line with that. And that's basically what we're trying to do.
So house number 1 exists now?
Yes, house number 1 exists now.
And that one a house you built, that was just...
Actually, it was a house we renovated, and I have a before and after of that. We've been renovating and fixing up houses in Woodbine. This is the first time we've ever tried to build one.
And so the setback you're asking for is the exact setback from the house that's listed as number 1 on our...
Correct. We asked him to do that so it lines up with the other one. So it would sit basically just side by side.
And when was the existing house built?
1920s.
Okay.
And when I first started this whole process, the reason that I was given that lot was so long versus deep is that originally that was going to be a road that was going through there a very, very long time ago. So that's why that lot is shaped the way it is.
And there is a house behind you on that really strange...
That 428, is that what you're referring to? Yeah, yes, it sits... And it actually faces a completely different direction. Its front door faces that number 60. So it's all a little strange on that little area there.
And so, let me just make sure, actually, these numbers are small. So you're asking for about a 26-foot, so the issue is the front setback?
Yes, ma'am. We're asking to go 25.9.
You're asking for 25.9. Your neighbor to the...
Left is 25.9.
But the
on the
neighbor to the
existing house.
right is 42.9.
Yes,
Okay.
but as you can see, their lots
Yeah.
are twice as deep.
Okay.
Any other questions of the applicant?
No.
Do you have anything else to add?
I don't think so.
Close the public hearing. Discussion.
I mean,
I think it's fine to line up with the existing home that was built in the 1920s due to the shallowness of the lot. And if you all agree, I'll make that a motion to approve the setback variance request due to the shallowness of the lot.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck.
Thank you for your time.
John Michael.
Mr. Chairman, the next case to the board is 2018-500. 500. That's involving the property at 2154 Byram Avenue.
Yes, you say that. So, John Michael, give us a little history on the number of BZA cases normally at this time of year.
I'll do it briefly, Mr. Chairman. As you'll recall, I was the attorney for this board for a number of years before moving in with the Codes Department. The longest list of BZA case dockets that I recall put us right around 130 cases in a calendar year. We're on pace for a little over 700 right now. So, viva la Nashville.
Boomtown, It City. Okay.
For case 500, Tom Farrell is our appellant and owner of the property located here again at 2154 Byram, Council District Number 17. The request for this case is for a variance from driveway number and width restrictions in the R6A zoning district. As we've referenced earlier today, the alternative zoning districts, or A districts, carry certain design guidelines with regard to everything from front-loading garages to number of driveways allowed to width of driveways allowed to where the parking areas can be with regard to the front setback on the property. And we've had a number of cases that come to the board are seeking variances from one or more of those conditions, just as with this one. The request for this HPR duplex construction is to have the parking in the front with the 2 driveways at 22.5 feet each. The restriction is for 1 driveway to the interior of the property at 12. So the request is for 45 feet technically instead of the 12-foot wide driveway as restricted. Is there anyone here in opposition to case number 500? Seeing none, the appellants will have 5 minutes to make the desired presentation. Just please introduce yourselves by name and address.
Thank you, ladies and gentlemen. I'm Tom Farrell, owner of Legacy Builders of Tennessee Incorporated. And the property owner is here with me, Mr. Chris Spencer. When this property was purchased back several months ago, I went to the code officials and found out we could build 2 properties there, and they informed me that it was okay to build 2 properties. So we purchased the property and tore the existing structure down and presented our plan to the board to get a permit. Upon finding that, I found out that this R6A had been passed and that our parking would have to be behind the front setbacks. So in all of trying to figure this out, and I brought a thing to show you today, which is kind of what you have on the screen. The problem with this property is there is a Metro sewer and an easement that goes right around the back of the property. So we really can't push the houses back to get the parking any further back because there's no way to do it back on the sewer easement. And also, my thing is this is our property, 2154 Byram. This is next door. That's next door to that. Next door to that, all down the street, everybody has parking in the front all the way down the street. We're the only one that they're trying to have pushed back, and we want to be aesthetically just like the rest of the properties on the street. I did contact the councilman and had discussion with him, and he was very nice. He was in the middle of all the fairground stuff, as you can imagine. Didn't meet with us, but he said he was neutral on the issue and didn't have a problem with it.
Oh, well, read it.
Well, I mean, as Councilmember Sledge.
Yes, sir.
He had sent us a summary of what he supported and didn't support, and on that one, he had said he wasn't supported.
I have his email right here. He sent me. He said.
What date was it?
What date was it? August the 20th, 2018. He said, thanks, I'll be neutral on this. Here's his email.
Okay, we have an email on September 13th.
And all it says is, it goes against R6A, I'm opposed, it goes against R6A, I think. I can't find it in front of me, but I think that's.
So let me ask John Michael, he held up the picture of the 6 houses. Why do we have this zoning and why is it affecting him?
Why do we have this zoning? When council passes the new A districts, it actually changes the design guidelines, and we're seeing it more in residential neighborhoods than we ever have in the past. The A districts have not existed for more than about 4, 5, 6 years at the most, maybe not even that long, but we are seeing more of the somewhat interior council districts that are closer to the downtown or midtown cores utilizing these A districts. As to other properties along this street, I'm sorry that I don't have the
So the
permit
real
dates
reason
vis-a-vis
this was
zoning change.
passed was what? These districts?
Don't presume to speak for the council
Okay.
who passed.
Well, what was the legal effect of these A districts being passed?
As far as the residential version of the A districts, a lot of what you see is these types of design guidelines, getting parking out of the front, having no front-loading garages, creating more of a front porch environment than a back deck environment, and meeting certain planning objectives along the way, presumably.
Okay, so the biggies are no parking out front, no front-loading garages, and so now that this is in place in his district, that's why these other houses, which were built before those laws went into effect, can have those.
Again, can't speak to the permitting dates on those necessarily.
Okay.
And so why is it necessary to have 2 driveways instead of 1 driveway? I understand the need for the width, but why the need for 2 instead of 1?
I understand, and I just read that myself this morning, and that's not necessarily the case. Matter of fact, the house directly next door, they have one 20-foot driveway, and then they balloon out to parking areas, and I'd be fine doing that, just having one 22.5 access from the street, and then have parking on the left and the right side of the 2 properties we're building.
But John Michael, under the district, how wide can your driveway be? 12. Okay, any other questions of the applicant?
What's the minimum driveway width? Do you need 20 feet?
Well, I mean, I don't want people fussing at each other because the car's in the way. I'd be accustomed to anything you'd let us have, just so we could have an entrance. I think one entrance and then balloon them out to where the two properties, we'd be fine with that. So if we're able to have 22 feet and then balloon out to the left and right for parking, I think that'd be fine, and nobody would be in each other's way.
Okay. Any other questions of the applicant? Anything else to add? Okay, we'll close the public hearing. Discussion.
I also think that I would want it part of the record that the applicant has provided 5 homes on the same street that have similar parking that he is requesting. And while I respect the councilman's opposition because it's not in accordance with the zoning, I think as to this street, it seems appropriate to grant the variance.
Yeah, I tend to agree, and I don't see the hardship for 2 driveways, and that's why I asked the question. The sewer easement, I think, does cause a hardship. And exactly as you said, I think that if this were the only one on the street wanting to do this, it would be a much bigger issue than being the last one on the street in a line of 5 that are already there.
The only thing that gives me a little heartburn is what the councilman said, oppose as this goes against the R6A zoning the neighborhood requested. It's always hard when a neighborhood, presumably they went through a rezoning to make it R6A, and it's always hard when neighbors want something and they go and get it done, and then we grant a variance to it. But
I totally agree.
Yeah, in this case, no one
agree.
is here in opposition.
But I also agree that the easement, the metro easement causes a unique hardship for this property.
And that's fine. I just wanted to point out,
Yes.
they went through a rezoning, but no one came here to speak in opposition.
Well, and I doubt anybody's watching or caring, but if anybody's watching or caring and wanting to do this on their property and it's not the exact same situation, I'm not going to be sympathetic because, just the fact that you have a sewer easement doesn't mean that you get to realign your, they're not asking for front-loaded garages. They're asking for a parking pad, not a front-loaded garage. I think that is a difference too. But so yeah, it's a very unique situation.
Does anyone have a motion?
The driveway number and the width restriction. But what you're saying is you can do one driveway, but you would need a variance from the 12-foot maximum of that driveway in order for your access to the property, and then.
I think we can do exactly what we did next door. If we do 22.5 and then balloon out to the 2 parking areas, we'll be fine with that.
So I think what the variance is as to the maximum width. And you said you needed 20 feet to build a driveway. So I would make a motion that we approve a variance of 20 feet for one driveway as access to this property.
Okay, motion's been made. Is there a second?
And the width of the parking pad, is that something they can do, or do they have to have a?
I think you would need to specify that to the extent they need a variance to fit the parking pad in the front setback, which is at 34 based on contextual, that would be part of your variance also, with the balloon concept that the appellant described.
John Michael said.
Okay, the motion has been made. Is there a proper second? Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael, can we take a short 5-minute break?
Take a short break and reconvene with case number 504 after the break. Deferred to the October 4th agenda. Mr. Chairman, we wanted to take up the what had been set for originally the top of the docket, our motion to set aside the previously heard BZA case 2018-369, property involved located at 720 McFerrin Avenue. The request had been for a sidewalk variance for a new use at that subject property. However, while passed on consent, there had been a communication failure of some sort, and it was not clear what conditions were attached from the planning department with regard to that approval on consent. As a result, it only seemed fair to give the prior appellant and property owner the opportunity to have that order set aside in a new hearing after new notice requirements have been fulfilled. Toward that end, staff humbly recommends passage of this motion to set aside and would ask the board to take up a motion at this point.
Do we have a motion to set this aside, and then we'll hear it again?
Yeah, I mean, I was not there in July, so I don't know if it's appropriate for me to make the motion, but I think
Okay.
since it is a motion
Yes.
to rehear, I would.
Yeah, well, I'll make the motion. I'll make the motion that we set aside and then rehear the case. Is there a second?
I'll second that.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. So we'll rehear the case in October.
Very well. Mr. Chairman, that brings us to the next case on our agenda, which is 2018-506. It involves a property at 521 Arrowwood Drive. William Haynes is the appellant and co-owner of the property. The request is for a variance from height restrictions, the RS-20 zoning district, to construct a detached accessory structure. You may recall this property was before the board, I don't know, 2, 3, 4 meetings ago. The request was similar in nature in that it was a detached accessory structure in question. However, the request was both for setback variances and for a 24-foot height variance. Here, the request is for a 20-foot height structure, where 16 is the cap. Therefore, the variance request for 4 feet above the 16-foot restriction. There are opponents present. As a result, both sides will be given 10 minutes to address the board with regard to this case from the prior site visits. There's 521 Arrowwood in the Creve Hall Neighborhood Council District number 26. Your packet, as completed, should include a number of letters of support, including correspondence from the district council member in 26, Jeremy Elrod. After the appellants make their presentation to the board, the opposition will have the opportunity to speak. For the appellants, if you want to save some portion of your time back from this originally allocated 10 minutes, that can be used for rebuttal. Just introduce yourselves by name and address, please.
Press the button, bottom button.
William Haynes, 521 Arrowwood Drive, and this is my wife.
Okay.
Hello again. It was 6 weeks ago we came before you asking for a rear setback and a height variance request, which y'all graciously allowed this rear setback, but denied the height request, which was 8 feet. With respect to your time, I'll keep this fairly short and sweet. We established the hardship before, and none of that has changed, which is growing family, also a crazy lot where, due to the flood zone, we have a half an acre, but not a lot to use, so we need to build the garage. Want to put a room above it. I'm back to request a variation for three reasons. Last time, you saw our desire to do it, and you saw one neighbor showing up in opposition, but really nothing else. This time, you should see in your packet before you 5 or 6 letters of approval or support from.
About 8.
Okay, I didn't know how many actually sent in. There were several telling me they would. And these are neighbors directly across the street from us, behind us, the other side of us, who are very much in support of it because they feel it raised their property values and look really good, including Councilman Elrod. Second, and to discuss the opposition, just to bring out the elephant in the room, there is a property line dispute between myself and the opposing neighbor who is represented by Mr. Fusner there. And the situation is, in July, when we were out of town, our neighbor put a fence on our property. Obviously, this is in dispute, but where we say the property line is where Metro zone map says it is, and we also had an appraisal, a survey done, which complies.
Keep doing it. You don't have to hold it.
You have to keep your phone.
Oh, good. That makes it much easier. We had a survey done, which also complies directly with the zoning map. And so we filed action against her in civil court to get her to remove the fence. Now, that's not you guys' deal or responsibility, and I realize that, but it does explain why they're being, that's her reason for opposing us, is because there's bad blood between us due to the property line. That's the only reason. It actually probably helped her property value as well as anybody else's.
Well, we'll ask her about that.
True, yeah. And the third reason is I took your advice. When we were here before, you guys kind of debated the issue and said, you know, we're worried about what this will look like, an extra 8 feet, and you have a one-story home. And so I went back, revisited the plans. I came up with a design that would basically, with the use of risers and dormers, where, you know, basically the room above the garage will come up probably a few feet and then start vaulting in. I even included a couple of examples of that in the packet that should be very similar to what we're trying to do. So, and last time I came asking for 8 feet, now I'm coming asking for 4 feet, and I'm hoping that maybe that will make the difference. So I'll save any time for rebuttal, I guess, at this point.
Okay. Any questions right now for the applicant?
Did you say you had some drawings or examples?
I had some examples. It should be in your packet.
Do you have copies
I
of
don't
them
have
there?
it. Could you?
Oh, no, I gave them to the, yeah, I gave them to you.
Have any?
No, it was whenever I submitted the packet. It just shows a garage with a room above it that shows windows coming out and dormers and stuff like that. I figured
4 feet?
No, they weren't exact. They were just examples that I printed out.
Oh, so you just printed out online just what's it going to generally look like? Is that what you're saying?
Yes, sir.
Okay, so it's
Does
not
it
what.
have
I didn't want to spend thousands of dollars on it with an architect, and then y'all say no and have to do it again. So I don't have exact plans. I was just submitted examples of what it would be similar to.
Does it have a sloped roof?
Yes, it will have a roof to match the house. I plan to brick it to match the house as well.
Okay. Let's hear from the opposition, and you'll have 6 minutes and 34 seconds left for rebuttal. Opposition, please come forward, state your name, address, and why you're opposed.
My name is George Fussner. I'm an attorney in Brentwood. My address is 7104 Peach Court in Brentwood. I represent Miss Helen Underhill. She resides at 517 Arrowwood, which is the property immediately to the left of this as you look from the street. She's quite elderly, has a heart condition, and physically is not able to be here or undergo the stress of something like this. We were here again on Election Day back in August, and the height request was for 24 feet, which was denied. There was a request for a variance on the back, which was unopposed and affect my client's property. I have submitted 3 pictures that are stapled together. These are the same pictures that we had last time. Yes, sir. That's it. They have the case number in the bottom right-hand corner. And the first picture, as you can see, shows the chain link fence. That's the subject of the litigation, but I don't think that affects this matter. And certainly the litigation has nothing to do with the opposition because it's not filed until after the previous request was denied.
So this is a new plan, 4 feet instead of 8. Why are you opposed to this?
Well, same reason as before, because as you can see from looking at this, there's a hill. He's going to build on a hill that's approximately 10 feet over my client's driveway. So if you add 10 feet and then put 20 on top of it, you've now put a 30-foot building effectively right next to my client's property and right next to her driveway. So you're cutting off air, you're cutting off light, all the things that is proper to deny a request. Further, there's been no demonstrated hardship here. Just because you have a growing family doesn't mean that the board needs to say, well, fine, you can build a garage with a room on top of it. Sounds to me like you can use the garage room for something else. But anyway, certainly if he wants to do a 16-foot building, that would be within code. However, we strenuously oppose the 20-foot again, so you're putting this huge building right on top of a driveway.
But he could build by right an attached garage that could add a second story to his house and be much higher than this is and actually much closer to your client. So why would that? why would that not be I mean, that's something that, you know, he said he would prefer to have a detached garage, and like I said, if if the garage actually touched the existing house, he could do it where he wants to do it now and go higher.
Well,
so, I mean,
if you look at where it is, you look on the first one, if he attached it and came out 24 feet, that certainly is going to...
But he could come out to the setback line.
Well, I understand that, but he's going to be 16 feet. He's not going to be 20 feet.
If he attaches it to that house, he can go up 2 stories, and you know, because it's attached to the house.
Well, that's not before us today. What we're here is on a zoning variance to put.
But I'm trying to
20
understand.
feet.
I'm trying to understand the extent to which you think this is going to cause light and wind and damage to your client's property, when it seems to me to be the kind of solution that one I'm not sure exactly. I don't think it's been established by either side, and I'm not sure where the burden is, but that there will be a shadow. I mean, you know, there's a lot of foliage between the two properties where it appears the garage is going to be, so I'm not sure that any building there would cause any additional shadow or light issue. And I can't speak to wind, but in terms of some of the things that you're talking about, and again, I understand it's not proposed, but there are options for this homeowner to build in a way that would be much more, you know, damaging in the ways that you're speaking of. So, you know, I mean, in terms of light and height and overlooking than what he's actually proposing. So I guess I'm really trying to understand how that extra 4 feet is going to cause your client harm.
Well, it does. I mean, the higher you go, the more difficult it is. And if, in fact, these two lots were flat, I think your argument is correct. It's not going to make any difference. But because you've got this 10 feet sort of start with, that creates further problems. And that's where the problem comes in. And then setting it to the left of his house rather than attaching it creates further problems. If he attached it to the house, then I think that would be less problematic, essentially putting it where the grass is next to his house and you see the driveway there. So there would be a significant buffer with nothing there.
Could you explain to me on your photographs of this driveway, there are some cones down at the end of the driveway. What do those represent, if anything?
I don't know. I did not take these pictures, so I don't know why they were in the picture at the time.
And what happens is the driveway goes behind this house?
Which house are you referring to?
Your client's house.
It goes up, and then there's a carport directly to the left, opposite to the left of those cones.
Okay, so I see a little blue sticking out. Is that
Yes,
the carport?
that's correct.
Okay. Does your client drive?
Yes, she still does.
Okay. And what else is in her backyard?
It's nothing.
Okay.
I mean,
so
everything, there's
the
an attached
extent of
room,
her-
but it's attached to the house.
Okay. And so in terms of her enjoyment of the property, you're talking about the light area. It would be blocking these windows theoretically, or a window that I see on the side of the home in this photograph?
That's correct. And further, she uses that carport as her main ingress and egress to the house, as well as that's where she parks her vehicle.
Sure. Okay, thank you.
You're welcome.
Any other questions for the opposition? Okay, anything else to add?
No.
Okay, thank you.
Thank you for hearing
We're going to hear from the applicant again. Okay, this is your rebuttal time, so you get to respond to what you just heard.
Yes, sir, thank you. I'll let my wife speak to the backyard shading issue.
Okay.
So after the last meeting, we wanted to make sure that the garage would not affect the lighting in her backyard. So we took several pictures at different times of the day when it was full sun, just to make sure, you know, where the sun was coming from. And so I think Jack has those printed out. And I screenshot them so you can see the date and the time if you'd like to take a look at them. But as you can see in the morning, the sun is, I'm bad with direction, but it's on the other side of her property coming in, so it would obviously not affect full noon the same. And then as it hits later in the afternoon, her full mature trees that are already existing on her property already shade her entire backyard. So it doesn't appear that the garage would affect that at all as far as her lighting is concerned. And also the garage where we would start, the garage would actually be back further than her carport parking area.
And you asked earlier about the of her backyard and what the blue was. I've got a picture of that in case you want to see it. The blue is actually a tarp. It's ragged and torn, but it's been there for several years. But you asked, so I brought it in case you wanted to see it.
And just to be clear that we know what the variance request is, it's 20 feet is what you're requesting overall height of the structure.
Yes, ma'am, that's correct. And to point, the second issue he's brought up before is the safety of the hillside, and the idea it's going to fall down. This is exclusively the purpose of Metro codes. You know, I've been through this process before. They come out, they inspect your footers. You have to get an engineer's letter. I mean, they're not going to approve something that's going to be a danger to falling down the hillside, in my opinion, because I think they're very good at what they do. And the thing that doesn't matter about this is the garage, especially now that y'all approved the rear setback going further in, is going to be so far beyond even the beginning of the garage, where her retaining wall is, that it won't affect it at all. And the last thing is, he brought this up before. He said this is self-imposed hardship. Well, we've sat through 2 of these meetings, and I'm sure and that argument, this is self-imposed hardship, that argument can be used for any of these. Oh, you bought this knowing that it wasn't zoned for that, or, oh, okay, in our case, we decided to have more kids. You know, I mean, pretty much any of these can be considered a self-imposed hardship, because that's when that's what your job, I mean, you guys are just determine if there's a reason for a variance on that, or what was already there.
But as I recall, I think I'm correct from the prior hearing that we had, the reason you're not attaching this garage to the house is because of the shape and nature of your backyard area. Is that right?
Correct. We can attach it to the house and lose some more of our backyard. And Mr. Taylor brought up a really good point. I've already talked to 2 Metro Codes inspectors, and they both said, hey, if you want to circumvent all of this, attach it to your home, even via a breezeway. And so, I mean, we need some space. And our other option is option A, to get approval from you guys. This will look better. It'll be lower. We care about the aesthetics of our home in the neighborhood. If y'all say no, then the only thing we have left to do is to attach it via breezeway. We can go up 30 feet. We can fill it full of bathrooms. Like, if we, you know what I mean? We can do anything we want. We don't want to do that, but my point is, like, we're trying to choose the less abrasive route. And you know, there's a lot of mature trees. You're not even able to see the garage from many angles from the road anyway. So, I mean, we're just trying to make it as pleasant as possible.
Any other questions for the applicant?
Yeah, I have 2 things. One is you stated the hardship as you don't have that much buildable property because of the flood zone and waterway that exists on your property. So that's a legitimate
Yes, ma'am.
hardship.
Yes, ma'am.
Okay. The second thing is I don't think Metro Codes is going to know anything about the soil underneath the structure you're intending to build. So if the structure falls down because of unsuitable soils, that's not the fault of Metro Codes.
Yes, ma'am, I understand that. I just meant that the hillside's been there for a long time, and that area is not moved, so.
That's fine. I'm just
Okay.
Okay. Yep.
Oh, okay, I understand. Thank you. Yeah.
Any other questions? Okay, we're going to close the public hearing. Discussion. So this is 4 feet instead of 8 feet. Variance.
I think they've made a good effort to reach out to the neighbors, and they have a hardship.
And we have a letter from the council person, and I mentioned there were 8 letters. There's actually 7 letters because the council person wrote twice in August and September of support. So there's 7 letters, including the council person's support.
Sure, I will move to approve the variance request to allow 20-foot high building maximum due to the hardship of the flood zone and waterway limiting their buildable area on their property.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. Good luck.
Thank you.
John Michael.
Mr. Chairman, the next case is 2018-507. Originally identified as a prospect for the consent agenda, is the appellant present for case number 507? With no appellant, Mr. Chairman, I would humbly recommend we defer that one meeting to the October 4th docket.
Okay, very good. Are we already on short-term rentals and it's not even 3 o'clock? Wow.
The record reflected at 2:39, we took up the first short-term rental case for today, case 2018-318, involving the property at 3117 Penn Mead Way. Craig Lizar is the appellant and owner of that property. The permit application was denied based upon prior operation outside of the scope of an existing permit. Is Mr. Lizar present? Craig Lizar.
Okay, let's defer this one meeting.
We'll defer that one meeting to the October 4 docket. And based upon prior approvals, Mr. Chairman, that will likely be our last go-round for case number 318.
Okay. Oh, has it been deferred before?
Once before. And then once we got quorum on it, where we were able to...
Oh, that one. Okay, gotcha. Okay.
Well, it's got some HOA issues.
But we'll, yeah, next meeting.
Mr. Chairman, the next case is 2010-482 involving the property at 7668 Old Charlotte Pike. Is the appellant present for case number 482? By way of background, Mr. Chairman, this case has a 3-year injunction from the court already based upon operation without the legally required permit. Property shown here at the Old Charlotte Pike address. An appellant or a property owner is allowed to file an appeal to the Board of Zoning Appeals, but of course any relief that this board gives does not overcome the 3-year injunction that's been put down by the court.
So we can't overturn environmental court?
Apparently they trump you, Mr. Chairman.
Come on, we're smart people. We've got 3 lawyers here. We can't overturn this. No. So explain to us, just for the people at home too, if you are in violation of our short-term rentals and everyone's here have been found in violation, they can appeal to us. They've been given a year punishment that they cannot operate or even list on short-term rentals, and so they're asking us to reduce that 1 year.
That's the idea. In fact, they can't even make a formal application for a 1-year period without permission from the board to reduce that 1-year wait.
So what happens in environmental court? If you go to environmental court and you lose?
Actually, Metro Legal is much better equipped to address that than we are, but in short, it's a 3-year version of the same thing.
What Mr. Michael said is correct. If the city determines that you're currently operating without a permit or have been operating without the permit, if we determine that through our own investigation or inspection, we will file a warrant to environmental court, have the hearing before the judge. If the judge determines that a property owner did in fact operate without a permit, the judge is required by law to, there's no discretion for him, so he has to give a 3-year injunction. So apparently this case came before the judge. He determined that a violation had occurred. The 3-year injunction was put down. So this board can consider the 1-year injunction, and you have some discretion, and you could give less than 1 year, but that does not trump the environmental court.
And Mac has just entered the room just on
cue. Do you know when this was in environmental court?
I believe it was just in environmental court last week.
I believe the notation was originally set for August 8, might have been the original hearing date, and then the 3-year injunction probably would have been issued at a later appearance.
And maybe when Matt gets caught up in a second, we're on case 482, but and I think we usually ask him for his history first, but it sounds like, I know for a while there, Metro was, because of the different laws and before this short-term rental kind of final law, so I'm sure it's not the final law, let's say the most current law, they went through a big process. I mean, it used to be that you would almost immediately go to environmental court, but for the last year or so, it took a lot to get you to environmental court, right?
Well, so the way the law works.
I mean, you had to ignore several things or.
Well, the way the law works, if a person comes into codes and applies for a permit, and codes determines that the person has operated without a permit, codes should deny the permit, and then they appeal to the board to determine if codes made an error. Environmental court, in the same section, it says if a court determines that there's a violation, then the court shall give it 3 years. So codes as a courtesy, they're not required by law, but as a courtesy, codes will send an abate notice to someone saying, hey, you were in violation of the short-term rental ordinance, you need to come into compliance. If the person continues to advertise and or operate after that notice has been sent, we then file a warrant to environmental court and then proceed from there.
Right.
And Mr. Vice Chairman, the net effect that we have found at the Codes Department is courts are frequently inclined to defer a court case to a later date so that an administrative remedy can be pursued, such as here at the Board of Zoning Appeals. However, when a defendant fails to appear in court to explain, I have filed an appeal to the BZA, that typically results in a default judgment, as was the case here.
So I'm sorry, one last clarification from what I previously said. I said the court found that there had been an operation. It sounds like if Ms. Thurley did not appear in court, it would have just been a default judgment, which is just the way when it works. When someone's noticed to come to court, if they don't come, the court will enter a default judgment.
Okay. So, Mac, tell us about this case.
On March the 4th of 2018, a host cease and desist letter was mailed. Estimated delivery would have been March the 10th. June 18th, inspection of the property continued to be advertised and operated. A warrant was requested. June 27th, Mr. Thurley emailed Robert Osborne. Mr. Osborne replied the 29th with an email to cease and desist advertising and operating without a permit with an attached copy of the March 4th host letter. At that time, the ad was removed. The case was adjudicated in environmental court on August the 8th, and the result of which was a court-ordered 3-year mandatory injunction.
Okay. Any questions for Matt?
What was that last part, August 8th? Something happened in court?
The case was adjudicated in environmental court on August the 8th. The result of that was a 3-year mandatory injunction against operating short-term rental property.
Okay, I have a question for one of our many attorneys. What exactly is adjudicated?
Decided.
That's what that means? Decided. So that doesn't mean that, okay, maybe we should let her testify.
I mean, adjudicated in the sense that it sounds like it was a default judgment, meaning it was on the docket, they didn't show up, and Metro asked for the ruling to happen to give them 3 years in absent of them being there, and the judge granted that.
So it likely means she didn't come.
She didn't come.
She didn't show up to court. Okay.
Okay, any other questions for Matt? Okay, thank you. We're going to hear from the applicant. Please identify yourself, your name, address for the record, and what are you asking us today?
I am Dawn Thurley, and I'm from 7668 Old Charlotte Pike. And wow, as confusing as this was for you, this is so confusing for me, but I'm becoming quite professional through all of this. I can.
So what happened in environmental court? You didn't show up?
When we got the red card on the mailbox on June 27th, everything that this gentleman just said was correct. My husband, we didn't know what that meant, and he drove to the address in Madison, where the card was from, and it was the sheriff's department, and they printed off a copy of, and I'm sorry, I don't know the terms of what it was, and it said STRP, and nobody knew what that was, but it had the phone number to Mr. Osborne. And
okay, so let's just cut to the chase here. I mean, you've submitted something which seems to be medical
it's
in nature. You understand we aren't the one that put the 3-year.
I do understand that. And when I filed for the appeal, that hadn't happened. And when I was sitting with David in codes, my understanding, because I sat down to do all this right, and he was like, oh, no, they've already done this, and you're going to have to file an appeal. And I'm like, okay. And so we went through all of that. And my understanding, and I even wrote it on my papers, is that when I didn't know there was a difference between I didn't even know environmental court. I wasn't looking at that. I thought this was all the same. And when we filed the appeal, I thought that pushed that to the side, that they would just go through that and we would
Oh, you're
come
talking about when
here.
you're filing our appeal, you thought the court thing would just be.
I did not realize they were two separate. And now everybody's like, well, giving me the whole explanation that environmental court is this and BZA court is that. Well, I didn't know that at the time, but I do definitely know that now.
Let me ask our lawyer a legal question. This is on our agenda, and we've been given the material. The person's here. We're hearing the case. Can we rule on this?
Yes, this board can rule on this because it is technically a separate issue. This is an administrative issue, so you can rule on this. Any penalty that this board assesses does not trump the environmental court. So if y'all determine that let's just say y'all determined that she would be eligible in 3 months, that 3 months would run alongside the 3 year. So at the end of the 3 month, the 3-year injunction is still in place. So you do have jurisdiction over her particular issue, whether or not the zoning administrator acted in error.
Okay.
That is not the same issue as that the court decided, which is that she was operating without a permit.
Does she have a remedy from her environmental court proceeding other than bringing an action to the Board of Zoning Appeals?
She could file something in environmental court if she wanted to.
Okay.
So basically, the answer to that question, and we're not giving any sort of advice, but I'm just repeating what that person, our lawyer, said, is that you could file an appeal with environmental court. And of course, to do that, you would need a lawyer. So that I will just leave it at that. But today, we are here to hear this particular case. So, okay, continue.
And I talked to Justin Marsh at environmental court, and he talked to Mr. Osborne, and it just didn't go anywhere. And so I guess I'm here to see if I can resolve this here. And then I wish they deferred it like you guys do here, since I didn't think we had to go if they had deferred it.
Well, we're not the environmental court. When they send you a notice saying you're supposed to be in court at this time and place, that's when you're supposed to be there.
I agree. I just assumed, again, that this was trumping that.
But we can hear this court case today, and you can go find a lawyer and see what your options are after today.
Thank you.
So continue. So what you're here to talk about, how did this happen? You had a short-term rental and you weren't licensed. Is
Right.
that correct?
As you can see the property, it's 52 acres, and actually that little triangle there is that white triangle is 7662, which is our property as well. So we have the 52 acres, and almost to the very back, we have our house towards the very back, and then my mother has a house, or did. She passed away in January, next to us. She had Alzheimer's, and we eventually had to put her in assisted living, and that was costing $5,000 a month. And we did it about 2.5 years, and the USB people who handled her funds were saying we needed to be prepared, and we were trying to think of things to do, and one of the things was renting her house, and I really didn't want full-time people being right next to us, because that's why we bought the property, was to be away from everything. And some friends had some traveling nurses, and they stayed with us at the end of 16. We were already about $150,000 with mom's care. So these long-term nurses came. That was great. Then another set of friends, and then we had friends from Destin that had VRBO'd. We went on VRBO, set it up. It looked like a great opportunity. I got really sick. Mom got really sick. 2017 was a wash. I think we had 8 renters in all of 2017. But at any rate, all that goes on to, we didn't know that we had to have a permit. We got the red card on the mailbox. That's where the story was going there. When Rod called Mr. Osborne's number, he had, in his message, left an email. We emailed just as that was confirmed. I went to, and this, oh my gosh. And in the meantime, I had even talked to licensing and talked to Roger, and he did eventually call me back and said that wasn't him, but gave me the number. We had a huge wedding, my daughter's wedding, in the middle of all this, which set my just timeline back, and I got really sick after that. But at any rate, I've just tried. I guess I've talked to everybody. I've done everything I was supposed to do. As soon as we found out we were supposed to do it,
Let me ask you a question, because you have submitted long, lengthy
I know, I'm so sorry.
health issue things. How did that have an impact on this situation in front of us?
Between time and my memory, I have 3 brain lesions and 2 spinal cord lesions. I've had brain surgery last July. Was in Johns Hopkins Hospital in Baltimore for 2 weeks, July, August, where I almost died from swelling on my brain and spinal cord until they figured out what I had. So I'm not all together, but I'm better and getting better, well, until today when they called me.
That's fine. You've told us a lot. Thank you. We have your brief. Thank you.
Yes. Okay. Other questions for the applicant? Okay. Anything else to add?
I did talk to the councilman, and he did support it. And he said he didn't need to come. And then when the environmental court came up after this and realized we didn't, and this became a big ordeal, he did call environmental court, and they said, I was going to have to I could do a motion to set aside. So I just have to look into all of that. I just need to do one step at a time.
Yes. Okay. We are going to close the public hearing and have discussion on this. So what is in front of us today, board members, is just like any other short-term rental appeal. We really, we are considering this case at the request of the applicant. And although the default judgment from environmental court is in front of us, we still have the power to rule on this case. And if the applicant wishes to appeal that default judgment, there are ways to probably do that, but we're not getting into that. But we're looking at the case in front of us today and what she is asking for relief of less than a year. So, board members, what do we think?
Well, I have no problem with allowing her to apply for the permit tomorrow if she'd like.
Is that a motion?
I will make that a motion unless someone else has discussion.
Okay.
Do we know, when was the last rental?
Well, she filed in July, so I think he said it was not advertised after sometime in March.
Okay.
Yeah. And since, so that motion has been made, is there a second? I'll second it. Motion's been made and properly seconded. Discussion. So, just like any other short-term rental appeal, like I said, we're discussing this. What I would say is, obviously our, reducing a year is not going to help her immediately because the environmental court default judgment of 3 years. But the environmental court can consider an appeal and can consider what this board did, but she has to go through the motions and file with them. So, any other discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously.
Good luck.
So what we have said is you still have to go to environmental court because their 3 years we cannot control. So, but if you get them to undo the 3 years, then you, by our board, would be eligible to apply for one of these permits.
Okay.
Thank you.
Thank you so much.
Mr. Chairman, we had previously called case 2018-318. Because of our uncharacteristically brisk pace, the appellant had not yet arrived for his case. However, he is present at this point. So I'll direct the board back to case 2018-318. That involves a property at 3117 Penn Mead Way. Another short-term rental case involving operation outside of the scope of a properly issued permit from the Codes Department. Craig Lizar is the appellant property owner. We'll invite him present or forward at this point. I believe you've had opposition both in person in the past and perhaps even in writing in your packet, raising questions and concerns with regard to homeowners association guidelines that may or may not restrict this use at this particular location. But as we always do, we'll remind the board that's not what you're reviewing today. That's something that staff will review upon application for a permit, and today it's just a question of whether or not the zoning staff erred in denying the permit and whether or not the board sees fit to reduce the 12-month required waiting period. With that, is there anyone here in opposition to case 318? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board. Please introduce yourself by name and address.
Good afternoon. My name is Craig Lizer. I live at 3117 Penn Mead Way, Nashville, Tennessee, 37214.
We're going to hear from our codes people. Mac, tell us about this case and what you know about it.
This case was opened through a host letter, advertising and operating without a short-term rental permit between February 26th and April the 11th of 2018. The advertisement was first posted on February of 2018. The host letter was sent April the 2nd. Estimated delivery was April the 9th of 2018. Mr. Lazar emailed Robert Osborne on April the 10th, and Mr. Osborne emailed Mr. Lazar on April the 11th and informed him how to come into compliance and file an appeal. The advertisement was subsequently removed on the 12th of April. The Board of Zoning Appeal was filed on May the 9th. There was one documented stay in March. No other action was taken by our department, and there were no STR complaints on this property.
Okay. So, Mac, any questions for Mac about this property? It says one stay. Okay, thank you. Please start again, name, address, and why you're here.
Of course. My name is Craig Lazar, Lizar, and I live at 3117 Penn Mead Way, Nashville, Tennessee, and I'm here to ask for a reprieve on the year time frame that you guys allot for.
So you operated without a permit. Why?
All right, so this is how the situation went down. This is prior to me talking to Robert Osborne. I had made a phone call to the zoning department before I ever signed up for Airbnb, and
When was that?
Early February.
The zoning department of the Metropolitan Government of Nashville, Davidson County, not like Mount Juliet or
I talked to some lady in
Murfreesboro.
Davidson County. I'm not that stupid. I talked to somebody in Davidson County.
We've
Now,
heard that before.
Well, here's the issue. I either falsely understood what she said or I misappropriated what I was asking. So I was under the assumption that with that and what I'd read that I was okay being a homeowner who was living in the house and was staying in the house, and any time that I was going to have somebody there that I was okay. All I had to do was file taxes. Lo and behold, I have one person come in, and they stayed with me for the one time. I got the letter. This thing is said it is dated March 28th. You guys apparently said you guys sent it to me on February 11th. I'm not denying that showed up on February 11th. It showed up. I immediately canceled all of my stuff, called Robert Osborne to try to figure out.
And how many were in the future that you canceled?
15.
15?
Yeah, I was booked all the way out through the year. I'm a single income father. All I was trying to do was trying to find a way to make ends meet with my kids. I got them half the time. So I was trying to make ends meet on the times that I didn't have them. So that being said, I cut everything off like I was supposed to. I shut down my entire Airbnb. I instantly called the collections, set up a tax identification number, paid my $9 in tax that I had for the one time that I utilized it, and instantly went through the process of trying to get the correct documentation and the correct permits that were required of me at the time. Again, I went back and forth with Mr. Osborne on a number of occasions, making sure that I was correct on the secondary adjustment. I came in here 3 or 4 times to have conversations. Eventually, it came back saying, well, because you got a letter, you need to go sit in front of the appeals board. He was very, very helpful and guided me and directed me on how best to come and have approach you guys.
Okay.
I made a mistake, simple as that.
Okay, very good. Any questions for the applicant? Okay.
Mr. Chairman?
Yes.
Just for a point of clarification.
Sure, of
The
course.
letter was April the 2nd. The February date that came in was the beginning of the operation date. Correct. But there was only one documented stay.
Very good. We're going to close the public hearing. Discussion. So canceled 15, rented once.
Yeah, I think it's clear by his own admission that the zoning administrator did not err, and he did rent prior to obtaining a permit. Since the date of filing, it's been 4 months since the date of filing and longer since the only rental. He has exceeded the standard penalty we would normally apply to this type of case, and so I would move that we allow this applicant to apply for a permit on Monday.
Okay. Motion's been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck.
Thank you, guys.
John Michael.
Mr. Chairman, case 2018-489, short-term rental case for Rachel Bubis involving the property at 1218 Lishy Avenue. Is the appellant present? Great. Is there anyone here in opposition to case 489? Seeing none, the appellant will have 5 minutes to make the desired presentation after hearing from staff with regard to this case.
My name is Rachel Bubis. I live at 1218 Lishy.
I'm sorry. We're going to hear from Mac first.
Oh, sorry.
Yes, that's okay. Mac, tell us about this case.
On May 26, 2018, the first online advertisement activity took place. July the 3rd, the host letter, cease and desist, was sent. That's it. Cease and desist letter was sent. Estimated delivery was July the 9th. Ms. Bubis emailed Robert Osborne about the host letter on July the 9th, and the website advertisement was removed on the same day. Mr. Osborne responded by email informing Ms. Bubis that how to file an appeal since she'd already come into compliance by removing the advertisement and being told to cancel any bookings. She filed the appeal on August the 4th. There were 3 documented stays in June, and there were no STR complaints, no other action taken by our department.
Okay. Any questions for Mac? No. Thank you. Please continue.
Well, I'll be repetitive to what he said, but okay. Yeah, Rachel Bubis is my name. I live at 1218 Lishy Avenue. I'm here to request to the item A appeal so that I may reduce the 1-year wait period to obtain my owner-occupied short-term rental permit. I travel occasionally for work for a local nonprofit, so over the summer I had the idea to sign up for the home rental service Airbnb to make a little extra money while I'm out of town traveling on weekends. Once I became familiar about the changing laws regarding STRP permits in Nashville, I started the permit process. I wrongfully assumed the process would take less time than it did, and I would have time to obtain the permit before my first booking. That was not the case, and I unfortunately booked my house during the weekends in June and the first week in July of 2018. I had my first booking on June 1st. I received my violation notice on July 9th. Immediately after receiving my notice, I removed my listing from Airbnb, canceled all upcoming bookings, and have not been listed on it since. I recognize my fault in illegally operating an STR and hope to appeal the wait period so that I may legally obtain my permit and get some much-needed supplemental income through house sharing.
Okay. Questions for the applicant? Do you have anything else to add? Okay. Thank you. We're going to close the public hearing. Discussion.
I think it's a little more severe than some of the prior ones because the bookings were not canceled prior to obtaining the permit.
How many bookings did you cancel?
I I think there were about 8, but I canceled them. As soon as I received the violation, I canceled them.
Right, but you applied for the permit, and then people did stay in your house in June, even though you didn't have the permit. That's what I heard the testimony was.
I was in the process after I found out, but I hadn't applied yet.
So after you found out what? I mean, so you didn't know before this?
I was misinformed about the process, so I was trying to get it after I'd already started.
So when you were misinformed, is that when you rented or after you rented? Or you rented after you found out and were misinformed?
It was pretty soon. It was right before I got the violation, so.
You rented right before you got the notice?
I did rent before I got the notice, yes.
But she was applying for a permit at that time.
Okay.
That's what I'm saying.
Yes, okay. We'll close the public hearing discussion.
No, I mean, I do appreciate, though, that they immediately canceled, and, I think there's, I agree and appreciate it, but I also think, that, to me, it's a, you tell me, we'll get to the right answer, but I was thinking, 3 to 3+ months past the last rental date, which would take it to the end of this, basically sometime in middle of October, which is, the other one is, was just so long ago. They had an essential 5-month penalty just because of the timing of it, and it didn't impact them. But I think you're right. There should be. Is that?
Do you have a motion?
You can go ahead. That's fine.
Well, I'll move that the zoning administrator did not err, and that the applicant, based on the circumstances here, is allowed to apply for a permit on October 20th.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? 4-1. So, 5-0. Okay, so October 20th, you could reapply. Thank you. John Michael.
Mr. Chairman, the next case is 2018-490 involving the property at 1815 12th Avenue North in Council District Number 21, a short-term rental case. Aaron Monti and Rebecca Ranks are the property owners. Appellants are present and represented. Is there anyone here in opposition to case number 490? There is. As a result, both sides will have 10 minutes to make the desired presentations for the appellant. Save any portion of this time you might want for rebuttal. And introduce yourself after we hear from Mr. McBroom on behalf of staff.
On May 10th of 2018, the first online activity took place. There was 1 documented stay in May and 3 documented stays in June. July the 3rd of 2018, the host letter was sent, estimated to be delivered July the 9th. On the 9th, Mr. Monti emailed Robert Osborne about the host letter and indicated that he had started the short-term rental application process on June the 6th. June the 9th, the advertisement was removed. On the 10th, Mr. Osborne sent an email reply indicating that due to the fact that the STR had operated prior to obtaining permit, Mr. Monti would have to cease and desist all advertising and operating and file an appeal with the Board of Zoning Appeals. And on the 4th, he did file for an appeal. There were
The 4th of what? I'm sorry.
on the 4th of August. There were four total documented stays, all of which were prior to receiving the host letter. There are no STR complaints on this property, and no other action was taken by our department.
Hello.
Name, address, and why you're here.
Okay. My name is Aaron Monti. I reside at 1815 12th Avenue North in North Nashville. Thank you all for your time. First, I just want to say I love my neighborhood and the growth that's happening in it with the new businesses that are popping up down Buchanan. I'm here to request permission to reapply for a short-term rental permit for my residents. I was misinformed about the requirement for a permit to rent out a single room inside my house. I operated about 4 times in June until receiving the notice on July 9th to stop operating. Immediately upon receiving the notice, I took down the room listing and canceled the one future reservation that had been made. I need to rent out the room, the extra room in my house as an income source, and appreciate your consideration in allowing me to reapply for the permit in order to do this.
And this is your personal home?
Yes.
And you are there when you have renters?
Yes, most of the, I travel for work as well, so sometimes I was not there, but I only rent out one room in it as opposed to the entire residence.
Okay.
Any questions for the applicant before we hear from the opposition? Okay, so do you have anything else to add before we hear from the opposition?
No, thank you.
Well, let me ask you this. Why didn't you know that you needed a permit to do this?
I thought that because it was just one room and not the entire residence, that a permit wasn't needed, and that was just from hearing from other people in the city.
So when you got a letter, what did you do?
So when I got a letter, I complied with the letter, took the listing down, and then emailed to get more information.
So you took everything down when you did? Okay.
Yes, sir.
We're going to hear from the opposition. Please go back in the audience, and we're going to hear from the opposition. Please come forward, state your name, address, why you're here in opposition.
My name is Simone Boyd. I live at 1910 Cephas Street. I'm opposed to this because there's new houses coming online pretty much every week in my neighborhood, and I think it sets a dangerous precedent if we allow people to operate Airbnbs illegally and then they get to approve them after the fact. I don't think it's fair that you can break the law and then comply. My second concern is that I think it's a public safety issue. I too love my neighborhood. We schedule cleanup days. We clean the alleys, but we live in a very challenged neighborhood. We had a drive-by shooting this week on 12th Avenue. Last year, we had a gun battle where gunfire rang out for 45 seconds. We had a murder the following week. And for people who are not aware of the fabric of the neighborhood, it's rough for them to be just walking around late at night, and we have that happening on our street now. If you know the neighborhood and you know what to look out for, you're aware of what's going on. But if you're just coming here for the weekend and staying in our neighborhood, I don't know that these people who are Airbnb are making people aware of their surroundings. That's all.
Any questions for the opposition? Okay, thank you for being here.
Appreciate it.
We're going to hear from the applicant again. Rebuttal time. You get to come back and respond to what you just heard.
Well, I would just say that I have never, I know about what has happened in the neighborhood, especially what happened the other day, but I've never felt myself, I've never felt really in danger, and I'm trying to, talk to the neighbors and form alliances with everybody around, and I think that it's actually helping the neighborhood be safer by having people not see it as a bad neighborhood, and having visitors come in and stay there and write reviews about how the neighborhood is good. So I would say that the reviews online are actually helping the neighborhood become a better perceived in terms of people from the outside. So thank you.
Anything? Okay, we're going to close public hearing. Discussion.
Well, I do appreciate the neighbor coming to express her concern, and it's not unlike other neighbors that we've had who have similar concerns, and it's concerns of folks that are really all across the city. And the task that we're given is, does this homeowner who has a right to a permit have a right to it now, or have a right to it a year from now, or somewhere in between? And we've always taken the view that, and the Metro Council has given the homeowner the right to apply for a permit to rent their home, his or her home. So to me, if you look at the kind of the seriousness of this particular offense, it's very much in line with others who, rented a room in their home, didn't necessarily know they were supposed to get a permit, got a letter, did everything they were supposed to do to be a good citizen. And so, that to me is in that kind of, that, 3-month, basic penalty that says, usually from, in my mind, from the time they stopped their bad behavior, which was the 10th of July. So, I think it's appropriate and fair for this applicant to be able to apply for a permit on October 9th, and I'll make that my motion after saying that I do believe the zoning administrator did not err based on the 4 documented stays that the applicant admitted to.
Okay.
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. He's eligible, October 9th? John Michael? To apply. Okay. John
Mr.
Michael.
Chairman, the next case is 2018-496 involving the property at 3614 Normandy Place North. Jonathan Weaver is the appellant on this short-term rental case. The appellant is present. We'll invite him forward. Anyone here in opposition on this case? Seeing no one, the appellant will have 5 minutes to make the desired presentation after the board hears from staff. Mr. McBroom, on behalf of staff.
The first online activity at this property took place on February the 10th, and a host letter was sent, excuse me, I apologize, that is not correct, on May the 10th, and a host letter was sent on February the 10th. Estimated delivery would have been February the 17th. June 22nd of 2018, the advertisement was removed. The 23rd, the advertisement was reposted. August the 10th, the advertisement was removed. And the Board of Zoning Appeal was filed on September the 12th. There were 4 documented stays prior to receiving the host letter, and there were no documented stays subsequent to that, and there was no other action taken by our department.
Okay. Any questions for Mac? No? Okay. Please get us started. Name, address, and why you're here.
Yes, thank you. My name is Jonathan Weaver. My address is 3614 Normandy Place North, and I'm here to request from the board that I can apply for a permit next week or as soon as possible. I do not believe the board examiner was in error as well, and when I was operating without a permit, I did that. It was a careless error on behalf of myself. And once I realized that I was unable to, I denied any dates for anyone to book further. I was unaware that what I actually needed to do was inactivate my entire profile. So when I went to actually apply for my permit, the zoning administrator actually saw that my profile was active. However, I was unaware that I needed to activate it. Exceptionally, I canceled all the dates so no one could actually book, as he mentioned. So essentially, what I did is as soon as I was aware of that, I deactivated my account and have not had any visits or requests since then. And so I have contacted my council member, Kathleen Murphy. I asked her about recommendations when appealing before the board. I have her email here to me. She said she was not closely aware of the rulings. It's best to be honest and upfront with them and show them as much evidence as possible. I also have a printout of evidence that showed my last booking was a year ago, August 20th, 2017. And so now we're about a little over a year since the last booking. I have tried to make everything in compliant with the board, with the zoning administrator, and my request is again that I could apply next week, and if anything else I'd need to do, I'd be happy to do that. I also have documents about my permit receipts of making all the payments and mailing out letters and discussing with my neighbors.
Okay. Questions of the applicant? Okay. Anything else to add? Why didn't you know that we had laws relating to short-term rentals?
Again, I didn't know about the laws, but that was a careless error on myself. I did not choose to investigate it when I applied. When I set up the profile, I didn't, and I knew friends that did this as well, and it was my fault. It was my error. I didn't investigate it, and when I heard from my friends who did this, they said the same thing. Of course, when I found out back in August 2017 that this was a problem, I stopped. I took off any more dates. I didn't do anything more for Airbnb. And then in February, I received this letter. When I received this letter, I still made sure there was no dates available, so I could not book. As he stated, I didn't book anything. And then when I realized I wanted to continue to do it, I then had to have the appropriate paperwork. So initially, it was my fault, my careless error of not following through with the proper zoning.
Okay, very good. We're going to close the public hearing discussion.
I have a question for Mike. You said your records don't show any, when does your record show the last documented rental?
It shows August of 2017.
Okay.
Discussion? I mean, it's a year out.
Yeah, I mean, this is one of those two where, I mean, I think.
So when would the year start?
Well, to me, people may have difference of opinion, but to me, I tend to think it's the last documented bad behavior. But I mean, I know that others have said, well, it's the day that you file because there's some consistency there. But in a lot of cases, those are so close that it doesn't matter. But this is the kind of case where it would matter. And so to me, again, it's just my opinion and respect the views other people may have. But to me, I think just in the cases where people rent a few times, stop, try to do the right thing, we've always imposed kind of that 3-month wait instead of a longer wait. And so I'll move that the zoning administrator didn't err, that we allow the applicant to apply for a permit on Monday, since that is well over the 3 months since the rentals, the illegal, so to speak, rentals stopped.
Okay, motion's been made. Is there a second?
I'll second it.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. You're eligible, what you said, Monday, to apply. Okay. John Michael.
Mr. Chairman, case 2018-497 is the next short-term rental appeal. Rose Bowe is the appellant and owner of the property at 524 Snyder Avenue, Council District Number 20. This item A appeal involves, of course, the short-term rental outside the scope of a short-term rental permit. All the information in your packet, including support, opposition, dates of rental after the original notice letters, et cetera, is included in writing. We do have opposition present on case number 497, so both sides will have 10 minutes to make the desired presentation after we hear from staff, in this case represented by Mr. McBroom.
On April the 9th of 2018 was the first online activity. There were 21 documented stays prior to the host letter. June the 1st, the host letter was sent, and estimated arrival June the 9th. June the 22nd, the advertisement was removed. The 23rd, however, it was reposted. There were 12 documented stays in June and 10 documented stays in July after the receipt of the letter, 22 total after the letter was received. August the 7th, BZA appeal was filed, and the advertisement was removed on August the 10th. There's an additional question about this property, which is not before you today, but we received information from a concerned citizen that this would not be an owner-occupied property. Facebook indicates that the primary residence is in Las Vegas.
Any questions for Mac? Okay, thank you. Name, address, why you're here.
My name is Rose Bowe at 524 Snyder Avenue, and I'm here to try to get my permit to do the owner-occupied Airbnb. My Facebook says I'm in Las Vegas, but my husband and I are going through a divorce right now, and I have 2 kids right now that are going to Belmont University and MTSU. So I'm living here, and my husband lives there. We've owned a business there for like 20-something years. I never saw the letter that he's talking about, sir, at all. Never saw any kind of letter. How I found out is that my real estate agent, who I bought the home from a year ago, said, I think your property would be worth more if Airbnb, because we told him we were Airbnb-ing. And So I said, okay. He said that it was only 6 permits allowed in that area. So I said, okay, I'm gonna go down there and talk to him and say, get an Airbnb permit. So when I went down there, he told me that I had been flagged. I said, what does that mean? He said, well, you've been advertising.
I'm sorry, when did you go down there?
On August 6th, I believe.
And so you just went on your own?
Yes, sir.
And so, but why did you remove the listing on the 22nd of June?
My daughter does this because she's the one who set up on the app on Airbnb, and she was in control of it. She is one that's doing it. She heard that a friend of hers was doing it, and that's why she recommended we do it to help with college tuition for her and my son Bronson. So she probably took it off and put it back on or something. I don't know. She's been the one that's been in charge on her app. And then as soon as we found out on August 6th, though, I went straight over within the hour, paid my taxes, and we took everything down. We didn't take any more clients. We were booked all the way, I think, almost to November. So no one else to stay there.
Did you cancel?
Yes, sir.
How many?
In fact, my daughter we fought with Airbnb because they first said they weren't going to allow us, they were going to fine us. And we said we had no idea we needed a license in the state, in the city of Nashville. And they said, well, who told you that? And we're like, the city of Nashville said we have to have a permit. And so we fought literally for almost an hour on the phone and went through every department we possibly could. And luckily they did cancel the rest through the end of October. So, but it was helping, financially through college tuition and stuff like that, so.
How many were canceled?
We were booked probably almost every day through the end of October.
So what do people rent when they rent 524 Snyder?
How much they pay?
No, what do they rent? Are they renting a room or they rent
No,
a
we
whole
have
place?
a back stairway that goes upstairs that has a kitchenette and 2 bedrooms.
Okay.
It's like a little apartment upstairs. So I got a guy to come in and put a door in the stairway that bolts from, up, down so they can't come down. So.
Okay. So how much does that rent for?
About $100, $80 to $100 a night.
Did you pay taxes on all
Yes, sir. He told me what I owed. David did in at codes, whatever, and I went straight over to the department and paid right then and there.
Okay. Any other questions for the applicant before we hear from the opposition? Okay, we're going to hear from opposition. Please go back into the audience, and the person who's here in opposition, please come forward, state your name, address for the record, and why you're opposed to this appeal.
Thank you for hearing from me. I'm Leah Dorton. I live at 523 Snyder Avenue, right across the street from Rose, and I've not met you yet, so hello, Rose. This is not in opposition to the property being rented. This is in opposition to the short-term non-owner occupied situation. And throughout being here through the day today, I've heard several people that have stated that they were unaware that they had to obtain any sort of permits in order to be able to host an Airbnb. And with that, I'd just like to read what I've prepared. I've got, as you are aware, the owner previously neglected to obtain a permit. Therefore, we do not believe they feel compelled to abide by the regulations currently in place. This could potentially result in a loss of value in our property or difficulty with potential resale. There could be consistent problems that occur because the laws and regulations have not been upheld by the owner to this point in time. We are unsure that any precautions, that's a big one for me as I've lived in the neighborhood for 12 years, any precautions or reasonable measures might be taken in the future based on the intentional disregard for both regulations in place and the neighbors on the street. I would like to add to that we will respect and accept the decisions that are made and extend that we will be in support of our neighbors' rights with what you all find. With the amount of people that she has listed that have come in and out of that property, you can see the concern that if you're not upholding the regulations in the very beginning to get your permit, are you obtaining background checks and making sure that everyone that goes through follows the procedures just to keep me and my family safe. And I thank you for your time.
You said, because you live across the street, and the way this, I do still want to ask you about what activity you see, and are they renting the whole thing? Is it, do you just see one person there? Have you seen your neighbor? Since I know you said you just hadn't met, but have you seen folks since April?
Have you ever seen her before today?
Walking up and down the street, I've seen her a couple of times. I believe, you have a white dog? Okay, yes. Then I have seen them walking up and down the street, she and a gentleman and their dog.
So it does appear that somebody's there.
Yes, I have seen them at times, but that is also in question, sir.
Right, and so, and, you know, in the previous case, I mean, like I said, we have a lot of neighbors that come and are opposed to, you know, the fact that somebody can have a permit, which that's not, you know, we didn't decide that, you know.
Right.
We got to, you know, we can decide that you can wait a year or you can wait less, and that's really all we can decide if you rented without a permit. And then it's just based on the severity of the situation. And so, you know, just, you'd mentioned owner occupied or not, and the way that works is that the code staff, when you go and apply, they'll say, hey, the law says you have to prove you live there, and here's the way to do it. There's certain things you have to show, your driver's license, mail, other things. So I'll outline. And a lot of times people have it, and they really don't live there. But they meet that letter of the law, and they get their permit, and then the neighbors will complain and say, you really don't live there. Then it has to come back to us to say, here's the activity, and I don't think they really live there. And so the only question we're looking at today is, you know, did this applicant rent without a permit?
Okay.
And if she did, then how severe is it, and when would we allow her to reapply? The max is a year. If we said, no, you got to wait a year, and a year from now, absolutely, that applicant could go down and apply. But the council has said, hey, there's a lot of cases that are maybe less severe than that, so y'all determine it. So if it seems like we're not addressing the concerns, and I know you're still here, and just if it seems like we're not addressing the concerns you raised, sometimes that's just because this board isn't charged with addressing those concerns.
I trust that completely, and like I said, I'll respect what you say and respect her rights. I just needed to come before you all today to, you know, at least voice the concern of not being sure.
Right.
Exactly.
And we've heard all sides of the short-term rental issue since the day people started renting short-term, and it's frustrating sometimes when you hear these and you're not able to solve it. In that situation, but it also, I hope it's helpful just so you all know where we are, so that at least we're empathetic with what you have to say and hear it.
My colleague does such a good job of explaining that to the public, and we have a lot of people that come in, like both of you, stating similar concerns, and thank you for explaining that.
Yeah, like I said, that I just don't want anybody ever leaving here not feeling like they were heard.
Okay, thank you for that. Thank you.
And we're going to have the applicant come back for rebuttal time.
I totally understand her concerns. With my property, when people come in, they come into our driveway, and we have a really big, long properties. They park in the back. I have security cameras everywhere. I mean, literally everywhere, top, bottom, all doors, video, everything. So I'm very big on protection and not letting anybody stay in the house that's rowdy or anything. I barely even hear them upstairs. We've had a lot of clients, but I really, truly would like to put on the record that Airbnb, you know, really needs to let people know that in the city of Nashville that you have to have a permit to do this, and it's really, you know, messing up a lot of people, because I'm not dishonest. My dad's a police captain in Memphis, so.
Okay. Any questions for the applicant?
We also hear that a lot.
I know.
Okay.
But I stopped immediately.
The only thing I'm kind of hung up with on your case is that it feels like more than a coincidence that the ad was removed on June 22nd after the letter was sent on the 1st, which would have, I think you all would have said, gotten it around the 9th at the latest, and and then it was reposted the next day. I mean, the fact that it was reposted the next day, kind of falls into your testimony about your daughter, but it still just seems a little more than a coincidence. But
I promise you, we did not. I don't remember. I wish she was here. It was some reason we did it, and she relisted or something, but it was nothing to do with the letter. I promise you that.
There were 22 rentals after the letter was received?
Well, she said they never received the letter.
I never saw a letter. When I came into his office to get the permit is when he said I was flagged, and I was like, what does that mean?
Okay.
No, sir. I never got anything. I don't know if did they come certified? Okay.
Any other questions? Anything else to add?
Okay. No, sir.
I'll close the public hearing discussion. Counselor, do you have something? Okay. Okay.
Well, yeah, I mean, I think I expressed publicly all my concerns, and that is that, you know, it's not the first time we've heard that somebody didn't get a letter. I can't say why they didn't get the letter. They don't know why they didn't get the letter. And so, you know, the ad was removed in August. So to me, in my mind, the clock ticks August 10th, and I'm trying to figure out how long the clock ticks. I don't know if you all have any.
I would say 3 months from August 6th, which was the date of the filing. I think the advertisement was removed on August 10th, so those are similar dates. And if no one disagrees with that, I'll make that into a motion. Interesting. You're going, okay, that's interesting. I will, 4.
So the end of, well, or just say the end of. Yeah, well, yeah.
And 3 months is November.
Well, from the filing, though, I mean, I always say last offense, which would be late July. So that's where I. So I mean, somewhere between. So you said, you know, 3.5 from filing would put it into November, which would be. Is that right? Which would be 4 from July. Yeah. So I mean, I think that to me that would be the same.
Okay.
My clock started a little bit, you know.
Okay, so what is your motion now?
So I will move that the zoning administrator did not err, and that we assess, that we allow the applicant to apply for the permit on November 15th.
Motion's been made. Is there a second? Second. Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. We are out of here by 3:45. This is the shortest BZA meeting in the short-term rental sidewalk era from the Sunny West Room in the Howard School complex of the Fulton campus. And we are happy that John Michael is our new zoning administrator. We have had 3, and as I said last meeting, the first one, I don't know if Metro Nashville Network's still on the air. We're all leaving, but the first one has a room named after them. The second one is now the codes director. So, John Michael, you got some shoes to fill. See you next time.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.